Appearances, please.
May it please the noble court. My name is
Yes.
Mark Ikongbe. My humble appearance, my lord, is for the claimant. Most grateful, my lord.
Yes.
Yes. May my lord be pleased. Michael
Yes.
Onyishi. Michael Onyishi.
Yes.
For the defendant, my lord. We are most grateful, sir.
Okay, the case is for judgment, and I'll be reading the judgment right away. I'll be reading it directly from my system. Okay, before I proceed, to read the judgment, there's a preliminary statement I will read. This suit was instituted by a complaint filed by the claimant on 17th October 2022. The suit was initially being heard by my Lord Honorable Justice O.O. Oyewumi, who is now a Justice of the Court of Appeal. Trial of the suit had been concluded by His Lordship, and final written addresses had been filed, but yet to be adopted when His Lordship was elevated to the Court of Appeal. That was when the suit was reassigned to me. When the suit came before me, learned counsels for the parties informed the court that the parties have agreed to adopt the previous proceedings in the suit and continue with the matter from where His Lordship stopped. Learned counsels accordingly applied to the court to continue the proceedings pursuant to Order 62, Rule 10.5 of the rules of this court. The application was granted, and on 25th November 2024, the record of proceedings in the suit as conducted by Honorable Justice O.O. Oyewumi was adopted as the proceedings of this court. Counsels for the parties thereafter proceeded to adopt the final written addresses, which were earlier filed. The adoption was on 20th March 2025, and the suit was accordingly adjourned to 18th June 2025 for judgment. I was still writing the judgment when I became sick and had to undergo a spinal surgery on 31st May 2025. After the procedure, I had difficulty sitting down, and as a result, I was unable to conclude the judgment up till the time the constitutional period of 90 days within which to deliver the judgment lapsed. The judgment is now ready and to be delivered today outside the 90 days period. After the delivery of the judgment, I shall make a report of this development to the chairman of the NJC pursuant to Section 2946 of the Constitution of the Federal Republic of Nigeria, 1999. I will now proceed to read the judgment. The claims sought by the claimant against the defendant in this suit are as follows. The claims are listed from numbers 1 to from numbers 1 to 8, and in relief 9 there is the claimant seeks alternative reliefs to relief 6 to 8, and then there's relief 10 as well. I have carefully set them out in the body of the judgments. I have also summarized the case of the claimant and that of the defendant as contained in the pleadings of the parties and the the evidence adduced by parties. I have also touched on the addresses. First, I will deliver a decision on the motion filed by the defendant on 25th January 2023. On 25th January 2023, the defendant filed a motion wherein it sought these prayers. 1. An order setting down for hearing and disposal before the trial of this action. The applicant's points of law, preliminary objection raised in paragraphs 1, 2, 3, and 4 of the applicant's statement of defense. The said objection being such as will substantially dispose of the claimant's claim against the applicant. 2. An order striking out the claimant's claims against the applicant for want of jurisdiction. The motion was supported with an affidavit and a written address. In opposing the motion, the claimant filed a written address on 7 February 2023. The defendant also filed a further affidavit and reply on points of law on 13 February 2023. The motion was heard on 13 February 2023, but the ruling was deferred to be delivered after trial of the matter. It is appropriate to determine the motion at this stage before going into the judgment in the substantive suits if the motion does not succeed. Prayer 1 in the motion is for an order setting this motion down for hearing before the trial of the suit. This prayer has been impliedly granted when the motion was heard on 13 February 2023 before the trial commenced in this suit. There is no longer any need to consider the prayer. In prayer 2, the defendant sought an order striking out the claims of the claimant for want of jurisdiction. Upon perusing the affidavit and written address filed in support of the motion, I observed that the reason the defendant is seeking to have the claims or suit of the claimant struck out is that the claimant I'm sorry, In prayer 2, the defendant sought an order striking out the claims of the claimant for want of jurisdiction. Upon perusing the affidavit and written address filed in support of the motion, I observed that the reason the defendant is seeking to have the claims or suit of the claimant struck out is that the claimant failed to mark the documents front-loaded with the complaint as exhibits and also failed to attach all the documents he will rely on. According to the claimant, this failure offends the provisions of the NICN filing of applications through motions in trade union matters and marking of exhibits practice direction number 1 of 2022. And for that reason, the claims or suit of the claimant be struck out. I have heard the arguments made by learned counsel for the parties for and against the application. I will straight away determine the application. I have examined the originating complaint and the statement of facts to verify the complaints made by the claimant in the motion. I find that the several documents pleaded by the claimants in the said statement of facts were front-loaded, and each of them were marked as exhibits. The marked documents range from Exhibit 1 to Exhibit 16. The claimant front-loaded the pleaded documents and also marked them as exhibits in compliance with NICN filing of applications, motions in trade union matters, and marking of exhibits. Practice Direction Number 1 of 2022. I cannot therefore find any justification for the prayer sought by the defendant. Assuming the claimant failed to mark the documents front-loaded with the complaint as exhibits and also failed to attach all the documents he will rely on, as alleged by the defendant, is that default sufficient to occasion the striking out of this suit? I do not think so. The documents which the claimant intend to rely on in this case are already now properly in evidence and marked as exhibits. Thus, the contention of the defendant has now been overtaken by the event of the documents transmuting to documentary evidence and properly so marked as exhibits. Let me also add that the failure of any party to mark front-loaded documents as exhibits is merely a matter of irregularity, which is not fundamental as to result to the striking out of the suit. In any proceedings in this court, the court is empowered in Order 5 Rule 6 Sub Rule 3 to apply fair and flexible procedure and shall not allow mere technicalities to becloud doing justice to the parties while considering any matter before it. Accordingly, to strike out a suit merely because there was a failure to mark front-loaded documents as exhibits contravenes this provision of the rules. It is my conclusion that the motion lacks merit. It is dismissed. Now, the decision in the substantive suit. The claimant was employed by the defendant on 2nd October 2018, and on 24th May 2022, his employment was terminated by the defendant. The claimant disputes the termination of his employment in this suit and also made some monetary claims on account of the termination of his employment. By the claims of the claimant, there are two aspects to consider in this case. The first part is with regard to his claim that the termination of his employment was wrongful. This is contained in Reliefs 1, 2, 3, and 4. The second aspect is the monetary claims covered in Reliefs 5, 6, 7, 8, 9, and 10. Before I examine the claims, let me observe that Reliefs 1, 2, 3, 4, 5, 6, and 7 sought by the claimant are declaratory claims, while Reliefs 8, 9, and 10 are ancillary monetary claims founded on the declaratory claims. It is settled law that in any suit where a party seeks a declaratory claim, such a party is required to prove the claim with cogent, credible, and satisfactory evidence. The law placed a heavy burden of proof in a declaratory claim on the party seeking the claim, in the sense that declaratory claims are not granted as a matter of course or even on admission by the defendant or on the weakness of the defendant's case. A claimant is expected to establish his entitlements to the declaration by his own evidence. Accordingly, the success of a declaratory claim sought by a claimant depends on the quality of evidence adduced by him to prove the claim. See Sule versus Habu 2012, Ada versus Ubandawaki 2015, and Zakala versus Edosa 2018. In addition, Section 132 and 1331 of the Evidence Act 2011 places the burden of proof in a civil suit on the party who would fail if no evidence were given on either side. It implies that the burden of proof of the claim sought by the claimant is fixed on the claimant and will only shift to the defendant upon satisfactorily proving his claims. The gist of the declarations sought by the claimant in Reliefs 1, 2, 3, and 4 is that the termination of his employment be declared wrongful. The first step in determining these claims is to examine the content of the letter by which the claimant's employment was terminated by the defendant. The letter is Exhibit A8, dated 23rd May 2022. It reads as follows: Termination of employment. I'm directed to inform you that your services are no longer required by the Nigeria Labour Congress with effect from Tuesday, 24th May 2022. The sum of 907,459 naira 38 kobo only, being your 3-month salary in lieu of notice, has been paid into your account, while the finance department has been directed to compute and pay your end of service benefits, if any, to you. You are to hand over Congress properties in your possession to an administrative officer in the administration department. While thanking you for your contributions to the work of Congress, may I wish you the best in your future endeavors. Now, one of the complaints of the claimants about the termination of his employment is that the termination violated the defendant's condition of service, the defendant's fundamental aims and objectives contained in the defendant's constitution, and his constitutional right to fair hearing. In explaining the manner in which these conditions of service were violated, the claimant said during his employment, no query was ever issued to him, and before the termination of his employment, he was never confronted with any wrongdoing nor faced the disciplinary committee of the defendant. He also said no opportunity was given to him to defend himself before his appointment was terminated in violation of Section 12.72 of the defendant's condition of service. In response to the allegations of the claimant, DW1 said the termination of the claimant's employment was rightly done in accordance with Clause 3.1.1 of the Defendant's Staff Regulation and Condition of Service, which permitted the defendant to summarily terminate the claimant's employment with payment of 3 months' salaries in lieu of notice, which was immediately paid into the claimant's bank account. DW also said the right of the claimant to fair hearing was never infringed upon because the termination of the claimant's employment was not based on allegation of misconduct, and thus he did not require to be given opportunity to defend himself. The defendant's condition of service is Exhibit A. I have examined the provisions of the condition of service. Clause 3.1.1 provides as follows: appointment may be terminated prematurely by the member of staff concerned, whether or not on probation, by giving 3 months notice or payment of 3 months salary in lieu of notice in the case of a principal staff, and 1 month salary in the case of other staff. Similarly, the appointment of a confirmed staff may be terminated after due process, provided that equivalent notice or salary in lieu of notice has been given. While Clause 2.7 provides as follows: termination. An employee who is confirmed in his appointment may have his appointment terminated by the Congress on the grounds of general inefficiency. Tell them to stop making noise. I'm reading judgment. An employee who is confirmed in his appointment may have his appointment terminated by the Congress on the grounds of general inefficiency, provided that he has previously been warned at least 3 times by his head of department or state secretary that his work has been unsatisfactory, and a copy of such warning has been forwarded to the general secretary on each occasion. 2. The appointment of a confirmed employee shall not be terminated until he has been given an opportunity of submitting representations to the disciplinary authority through his head of department or state secretary, and such representations have been considered by the disciplinary authority. 3. A confirmed established employee whose appointment is terminated shall be given 1 month's notice in case of junior staff and 3 months for senior stroke principal officer. Alternatively, he or she shall be entitled to 1 month or 3 months, as the case may be, pay in lieu of notice, as well as any leave and benefit due to him. He may be allowed to continue to stay in Congress residential quarters for a period not exceeding 6 months. And 4, an employee who terminates his or her appointment by resignation shall be required to give a month's notice or pay a month's salary in lieu of notice for junior staff, and 3 months in case of senior stroke principal officers. He or she shall also be required to vacate the Congress premises within 3 months. In view of these provisions, the condition of service has provided 2 ways employment in the defendant can be terminated. Clause 3.1.1, 12.73 and 4 permits termination of the employment by period of notice or payment of equivalent salary in lieu of notice, while clause 2.71 and 2 applies to instances where employment is to be terminated on disciplinary grounds, either when the employee is found to be inefficient or for committing any of the offenses listed in clause 2.8. The letter of termination of the claimant employment reveals that the service of the claimant was no longer required by the defendant with effect from 24th May 2022, and that his 3-month salary in lieu of notice has been paid into his account. By this information, it is obvious the defendant decided to terminate the employment of the claimant because it no longer required the services of the claimant. The letter did not mention that the termination was informed by any complaint or allegation of misconduct against the claimant. DW1 stated that the termination of the claimant's employment was not based on allegation of misconduct. The claimant himself confirmed that the fact that his employment was not terminated on disciplinary grounds when he said prior to the termination of his employment, he was not accused of any misconduct and no query was issued to him. He also said he was not invited to face the disciplinary committee. Therefore, it was not in dispute that the employment of the claimant was not terminated for misconduct. The claimant contended that his employment was terminated in violation of clause 12.72 of the condition of service. The requirement of the condition of service in clause 12.72 is that a confirmed employee must be given opportunity to make representation to a disciplinary authority before the appointment can be terminated. Relates to the situation where allegation of misconduct which can result to termination is made against the employee. Where no allegation of misconduct is made against the employee, then no situation has arisen to require the employee to be heard by the disciplinary committee before his appointment can be terminated. In this case, where the claimant was not accused of any misconduct prior to the termination of his employment, there is no reason for him to expect that he should face the disciplinary committee or be given opportunity to make representation to the disciplinary committee before his appointment can be terminated. By clause 3.1.1 and clause 12.73 of Exhibit A, the defendant has the right under the employment to terminate the claimant's employment by giving 3 months notice or payment of 3 months salary in lieu of notice. The claimant's employment was terminated on 4/5/2022 by the letter dated 3/5/2022. The claimant was not given 3 months notice, but the defendant offered to pay 3 months salary in lieu of notice. Let me mention here that the claimant admitted receiving the sum of 907,459.38 naira, representing 3 months salary in lieu of notice in his account after the termination of his employment. The implication is that the defendant terminated the claimant's appointment in accordance with the provisions of clause 3.1.1 and 12.73 of the defendant's condition of service. I will now attend to the specific declarations sought by the claimant in reliefs 1, 2, 3, and 4. In relief 1, the claimant sought a declaration that the defendant can only terminate his employment in accordance with the terms and conditions of service. This claim represents the position of the law on matters of termination of employment. The parties to an employment contract can only terminate the contract in accordance with the terms of the contract or in the manner agreed by the parties. Where the employment is terminated, without following the laid down procedure, the termination will be wrongful. While relief one can conveniently be granted, I find, however, that the defendant terminated the claimant's appointment in accordance with provisions of the condition of service. Also, since the claimant's employment was not terminated on disciplinary grounds, the claimant's right to fair hearing was not breached. Consequently, I find that the claimant failed to establish the declaration he sought in Relief 2. In Relief 3, the claimant asked this court to declare that the termination of his employment is contrary to the defendant's fundamental aims and objectives to protect, defend, and promote the well-being and interests of all workers as contained in his constitution and its core values of honesty, accountability, and justice in ensuring fairness in his treatment of all issues and people. When examining this claim, I've wondered what the defendant's fundamental aims and objectives have to do with the issue of whether the termination was wrongful or not. The fact that the defendant's constitutional aims and objectives is to protect, defend, and promote the well-being and interests of all workers does not mean that it cannot terminate the employment of any of its employees at any time and for whatever reason. The defendant's fundamental aims and objectives do not fullness of the termination event. It is the view of this court that the termination of the claimant's employment is contrary to the defendant's fundamental aims and objectives. The claimant also sought a declaration that the termination of his employment without stating any reason is an unfair labor practice and contrary to international best practices as set out by the Termination of Employment Convention 1982, that's Convention number 158, and Termination of Employment Recommendation 1982, that's Convention number 166 of the International Labour Organization. See Relief 4. In his evidence, the claimant said the termination of his appointment is not in compliance with the Termination of Employment Convention number 158 of 1982, Articles 1, 3, 4, 7, 9, Article 1 sub 3, 4, 7, 9 sub 2. To which Nigeria is signatory or party to. The claimant tendered these instruments in evidence. They are part of Exhibit A10. In response, DW said the termination of the claimant's employment did not contravene the relevant provisions of the Termination of Employment Convention 1982, Convention number 158, and Termination of Employment Recommendations 1982, Convention number 166 of the ILO. First of all, when the court is to consider whether the termination of an employee's employment is wrongful or not, it is the terms and conditions of the employment that must be examined, and not extraneous instruments, which the parties did not adopt as part of the condition of service. Therefore, I do not think these instruments have any impact on the termination of the claimant's appointment, which was done in accordance with the condition of service regulating the employment. In addition, I've examined the pleadings of the claimant and the evidence adduced by him, but I cannot find where he mentioned how the termination of his employment violated Convention number 158 of 1982 and Convention number 166 of 1982 of the ILO. Since the claimant wants the court to consider the instruments in determining the wrongful nature of the termination of his employment, he is expected to plead and prove how his appointment can be terminated under the instruments and the manner in which the termination breached the provisions of the instruments. The claimant merely pleaded the instruments without demonstrating in his averments or in his evidence how the instruments affected the termination of his employment. I find that the claimant also failed to prove the declaration in Relief 4. The result of my findings in Reliefs 1, 2, 3, and 4, his employment was wrongful. In Reliefs 8A and 9A, the claimant sought to be paid the sums mentioned in the claims and said the sums represent 5 years gross salary as general or exemplary damages for the wrongful actions of the defendant, including the unfair labor practices and the wrongful termination of his employment. These claims failed for the reason that the claimant failed to prove that the termination of his employment was wrongful. The second part of the claimant's case is the monetary claims from Reliefs 5 to 10. While the claimant claims in Relief 6 that he was appointed as Director of Research Chief Economist of the defendant, but wrongfully not paid the wages and other entitlements for that office, his claims in Relief 7 and 8B to F are based on the wages, entitlements, and allowances he sought to be paid for the position of Director of Research Chief Economist from 2018 to 2022, when his employment was terminated. To be entitled to the claims in Relief 6, 7, and 8B to F, the claimant has the duty to prove that he was appointed the Director of Research to Chief Economist of the defendant, or that there was an agreement with the defendant to pay him the salaries, entitlements, and allowances of the Director of Research to Chief Economist of the defendant. The defendant averred in defense of the suit that he did not offer or give the claimant any assurance of employment into the position of the Director of Research or Chief Economist of the defendant, and there was no agreement contracted between the defendant and the claimant to offer him the position of Director of Research, Chief Economist. The claimant was employed as a senior assistant to the General Secretary in the letter dated 2nd October 2018, and he accepted the appointment. The claimant was subsequently redeployed to the position of Assistant Director in the Research Department of the defendant via the letter dated 18 December 2019, and he also accepted the appointment. The claimant only discharged the responsibilities within his job descriptions, but did not undertake any role as the Director of Research Chief Economist. With these averments of the defendant, the burden of proof of the claims in Relief 6, 7, and 8 rests on the claimant. From the totality of his evidence, the claimant did not say he was at any time appointed as Director of Research / Chief Economist. His evidence shows that he was first appointed by the defendant via Exhibit A4, dated 2nd October 2018. The appointment was to the position of Senior Assistant to the General Secretary, pending the completion, quote, pending the completion of process needed for appointment into Research Department, unquote. The letter also set out the claimant's pay for the position. Then he also received Exhibit A5, dated 18 December 2019, appointing him as Assistant Director of Research to head the research department and to also serve as the Secretary of the Economic Commission. This second appointment letter also set out the salaries and allowances of the claimant, allowances which the claimant was entitled to be paid for the position. This second appointment was the one confirmed by the department via the Exhibit A6, dated 18 January 2021. The claimant remained in this second appointment until his appointment was terminated in May 2022. The claimant did not produce any other documents wherein the defendant appointed him to the position of Director of Research / Chief Economist. The claimant is clearly aware that he was never appointed by the defendant as his Director of Research / Chief Economist. He also knew that the appointments in Exhibits A4 and A5 were not the same as being appointed Director of Research / Chief Economist. That is why the claimant has very bitter quarrel with the defendant for his failure to appoint him as the Director of Research / Chief Economist, despite the assurances given to him by the defendant. It is also clear that it is on the basis of the failure to appoint him as Director of Research / Chief Economist that the claimant is seeking to be paid what he ought to have been earning if he had been appointed into the position of Director of Research / Chief Economist. In his evidence, the claimant said his appointments in Exhibit A4 and A5 did not align with the defendant's scheme of service and condition of service, or the discussions and assurances that led to the claimant's acceptance of the offer. He also said, by the defendant's constitution, proper designation should be Director of Research / Chief Economist and not Assistant Director Research. Again, he said the emoluments reflected on Exhibit A5 as Scale 15, Step 8 did not tally with the consolidated salary structure for Director of Research / Chief Economist. These averments of the claimants confirm that his appointments in Exhibit A4 and A5 were not the same as the position of Director of Research / Chief Economist. From the case of the claimant, I find that what he relied upon which he basically his claim for the salaries and entitlements of the office of Director of Research / Chief Economist is the alleged assurances or promises which the defendant made to him regarding his appointment as Director of Research / Chief Economist, or assurances, thus imposing the burden of proof on the claimant. The claimant failed to discharge the burden. He was unable to establish to the court that such promises or assurances were made to him. Assuming he was able to prove that such promise was made to him, the fact remains that the promise remains a promise. Since the defendant did not appoint the claimant into the office of Director of Research / Chief Economist up till the time the claimant's appointment was terminated to appoint the claimant into that position. The claimant failed to prove that he was at any time appointed into the position of Director of Research / Chief Economist of the defendant as to entitle him to the salary or other entitlements for the office of Director of Research / Chief Economist. The claimant also failed to prove the existence of any agreement between him and the defendant for payment of the salaries, entitlements, and allowances of the Director of Research / Chief Economist to him. Let me add that the first appointment letter as Senior Assistant to the General Secretary spelled out the claimant's salaries and allowances for the position. The second appointment letter as Assistant Director of Research / Secretary of Economic Commission also contained the salaries and allowances for the position. There was no other letter given to the claimant which entitled him to salaries and allowances other than those in Exhibits A4 and A5. Thus, the claimant has not shown what entitled him to the salaries and allowances he claims outside those prescribed in his appointment letters. An employment relationship is created by an agreement or contract between two persons, and the position to place the employee, unless expressly agreed, is at the discretion of the employer. Thus, an employee cannot unilaterally force himself into a position in the employment when there was no express agreement of the parties to that effect. The duty of the court in matters of employment contract is to interpret and apply the agreement mutually entered into by the parties. The court does not make contracts for the parties. Accordingly, the claimant, not having been appointed by the defendant into the position of Director of Research Chief Economist at any time, he cannot assume that position for himself and claim benefits and entitlements meant for that position. In Relief 5, the claimant asks the court to declare that it was wrongful and discriminatory for the defendant to deny him entitlements due to him in his cadre as a principal officer. In proving this claim, Research Chief Economist was offered to him. The position made him a principal officer and a member of the National Administrative Council of the defendant. He said all the principal officers of the defendant were entitled to 36,000 naira monthly car maintenance allowance, a brand new Toyota Avensis car, and one allowance. With the position offered to him, which made him a principal officer, he would also be entitled to these entitlements in addition to the consolidated salary and annual housing allowance for chief economists in Exhibit A3. He averred that these entitlements were, however, made available to other principal officers except him. Further in his evidence, the claimant averred that as Director of Research Chief Economist, on consolidated salary structure and as a member of the Defendants National Administrative Council, he was entitled to annual leave allowance, monthly car maintenance allowance, a brand new Toyota Avensis car, annual housing allowance, annual medical allowance, and 13th month bonus allowance. He said these allowances were either not fully paid or not provided. In Relief 10, the claimant claims for these entitlements. A, 1,584,000 naira, representing unpaid monthly car maintenance allowance from October 2018 to May 2022. B, 22,600,000 naira, representing the value of a brand new Toyota Avensis car. C, 5,140,000 naira, representing unpaid annual medical allowance for 2018 to 2022. DW said in his evidence that the claimant was not employed as the defendant's Director of Research / Chief Economist, even though he was a member of the Defendant's National Administrative Council, but there were no monetary allowances attached to the office. The defendant did not provide or approve any special allowance or entitlement, such as annual housing allowance, annual medical allowance, monthly car maintenance, brand new Toyota Avensis to any member of the National Administrative Council. During the claimant's employment as senior assistant to the General Secretary, and when he was redeployed to the office of the Assistant Director of Research / Secretary to the Economic Commission, his salaries, leave allowances, other entitlements, and 13th month bonus were paid to him in accordance with the consolidated salary structure of the grade level applicable to the office position to which the claimant was employed. I have resolved earlier that the claimant was never appointed as the director I resolved earlier that the claimant was never appointed as Director Research / Chief Settlement meant for that office. It is, however, not a dispute that in his position as Senior Assistant to the General Secretary and Assistant Director of Research / Secretary to the Economic Commission, he was a principal officer and a member of the Defendants National Administrative Council. In this claim, where he claims entitlement as a principal officer, the burden of proof lies on him, particularly the fact that the defendants averred that no such special allowance as annual housing allowance, annual medical allowance, monthly car maintenance, or a brand new Toyota Avensis was approved for any member of the National Administrative Council. I have examined the evidence adduced by the claimant, but I find that he has not shown any term in the condition of service or any provision in the scheme of the defendant which provide for annual housing allowance, annual medical allowance, monthly car maintenance, or a brand new Toyota Avensis for principal officers other than his entitlements specified in his appointment letters. The claimant also failed to prove or produce any evidence to show that principal officers received such allowances or entitlements. It is clear to me that the claimant failed to prove the declaration sought in relief 5 and the claims sought in relief 10A, B, and C. In relief 9B, the claimant sought to be paid the sum of 1,598,281 naira 97 kobo, representing unpaid minimum wage consequential adjustment for 21 months from April 2019 to December 2020. In his evidence, he said the National Minimum Wage Amendment, the defendant decided to pay the consequential adjustment from January 2021 and not from when the act came into effect. The defendant only paid the minimum wage consequential adjustment for 11 months from January to November 2021 and therefore left 21 months minimum wage consequential adjustment unpaid from April 2019 to December 2020. The claimant said his proper minimum wage consequential adjustment from April 2019 to December 2020 was not paid and it amounted to the sum of 1,598,281.97 kobo. The response of the defendant is that after the enactment of the Minimum Wage Amendment Act 2019, the defendant immediately began the process of implementation and adjustment wage commenced in January 2021. The claimant was only entitled to consequential wage adjustment from the time of the implementation was accordingly adjusted and paid. Let me observe that this claim for unpaid minimum wage consequential adjustment is based on the claimant's actual appointments and the salary in Exhibits A4 and A5, and not the assumed position of Director of Research Chief Economist. The defendant admitted that the Minimum Wage Amendment Act was enacted in 2019, but confirmed that it started paying the minimum wage in January 2021. The period over which the claimant claims minimum wage consequential adjustment is from April 2019 to December 2020. It is therefore obvious that the defendant did not adjust and pay the claimant the minimum wage from April 2019 to December 2020. From the dates the Minimum Wage Amendment Act 2019 came into effect, the claimant is entitled to have his salary adjusted accordingly and paid the minimum wage to him. I find that the claimant is owed the sum he claims as unpaid minimum wage consequential amendment from April 2019 to December 2020. The claimant also seeks to be paid the sum of 5 million naira for cost of action and solicitors' fees and 20% post-judgment interest on any sum awarded to him. These are reliefs 10D and E. These claims too were not proved by the claimants. Having meticulously examined the claims sought by the claimant, I find that reliefs 2, 3, 4, 5, 6, 7, 8, A to F, relief 9A, and 10A to E were not proved. These reliefs are dismissed. Only relief 1 and relief 9B were proved, and they are granted as prayed. Consequently, it is declared, 1, it is declared that the defendant can only terminate the employment of the claimant in accordance with and as is envisaged in his conditions of service. 2, the defendant is ordered to pay to the claimant the sum of 1,598,281 naira 97 kobo, representing unpaid minimum wage consequential amendment for 21 months from April 2019 to December 2020. 3, the order made in 2 above is to be complied with within 30 days from today, failure of which it shall begin to attract interest at 10% per annum until it is fully paid. 4, parties shall bear their costs. Judgment is entered accordingly.
That's the confidence.
Thank you very much for your kind patience. I know the network was fluctuating as I read along. Copies of your judgment will be made available to you on Monday. Today is Friday already, and we are having a virtual sitting. Before I can get the file back to the registry, it will have to be Monday.
As the court
So
pleases.
thank you
We are
very
grateful, my lord,
much.
for
My lord,
the well-considered judgment.
Thank you.
my lord,
And
we
we
are
wish my
so
lord a quick recovery.
Thank you very much. I appreciate it.
yeah.
So in the absence of any other matter, I will exit the meeting room now.
My lord, we appreciate my lord for the well-considered judgment, my lord. We wish my lord a swift recovery, my lord. Thank you very much, sir.
Thank you very much. I appreciate. Thank you.